Hi everybody, Charlie Bowers here, and in this session we're going to go through a high-level presentation on estate planning. I know estate planning is not a fun thing to talk about because you think about death or incapacitation, but it really is important regardless of the size of your estate. Estate planning is important, and if you've never talked to an estate planning attorney, it might be a good idea to do that regardless of the size of your estate. So who benefits? Everyone really benefits. All your friends, you can benefit from having all of these documents, all of these plans in place in the event something unfortunate or untimely happens. So estate planning can be where you are able to pass your estate to your loved ones in a way that you want to leave it to certain charities, but it's also a way to, if you will, control your estate from beyond the grave. Because there's certain documents, legal documents that can be developed, created to help you make sure things happen the way you want them to, that you don't have a young son or someone that might just blow through the estate in no time, but that you can actually help him gain a little wisdom as he's growing and all of a sudden has access to what could be quite a large sum of money. So let's go through a few of these estate documents that not everyone necessarily needs, but it's something to talk about and something to think about for your specific situation. And this is where having an estate planning attorney help you is so vitally important. So first one, a will. And I think most everyone has heard the term will, and the thing you might not think about is, oh, you have a will, well then you're going through probate. Your estate is going through probate. And you might recognize that might not be the favorite term that you've ever heard, going through probate, because it's time consuming. You're not able to pass your assets to your heirs quite as quickly as you want to. It can be costly. It's not necessarily the best in many cases, but it is a document that says, all right, I want my things to go to these people provided there's enough assets there to do it. So you can have some expectation of your assets going where you want them to, and you're able to appoint a guardian if need be for young children. Trust, there are many different types of trust that can do all kinds of things, and this is the kind of document I was talking about where you can have all kinds of contingencies written in where, oh, I don't like my daughter's husband, so if something happens to me, I pass my assets to her, and then if something happens to her, I don't want him to get any of it. So there's ways to control what happens to your estate even after you're gone, because there can be a number of situations, as I mentioned, you might think kids might spend through so much money so fast, where you can limit the damage, if you will, in those circumstances. You can control your estate beyond the grave. But one thing I failed to mention before, try to pass your wisdom before you pass your wealth, because you want your values in your children. And unfortunately or fortunately, oftentimes you have to pass those values down when the kids are young. So don't forget your grandkids. Try to pass your wisdom down to your grandkids so that your values will continue. And if estate is left, then you'll be able to have them enjoy it and live with your values moving forward. Power of attorney, healthcare power of attorney. Now think about this. These are the documents you need if you're still alive but become incapacitated. If something happens to me, I can't make a medical decision, I'm in the hospital, I need someone to be able to make those decisions for me, like my wife. If that's the case and I can't access certain checking accounts or brokerage accounts or whatever it happens to be, maybe I need a power of attorney that can sign for financial decisions. So it's important to have these documents as well. Letter of intent. We have what we call a survivor's guide. You know, it's tough enough as it is when a loved one passes away and you have the emotional strains, but it's also much more difficult when you have all the financial, funeral, and other areas that have to be taken care of. It's hard enough, just the emotion of losing someone, but to have to take care of all of their stuff as well is tough, especially when maybe there's several children and you don't really know what the intent was or what they want. So a letter of intent says, I want my shotgun to go to my son, I want this car to go to my granddaughter. Just a way to help the survivors understand, you know, what your intentions are, what you would like to see happen with some of your assets. Do not resuscitate. I think we know what that means. If you're in a hospital, confined to a hospital on life support, and the question is, do we keep Dad alive, or does he say make no extra effort to keep me alive? You know, that's a personal decision and something you really should talk over with your family too, so that if you have several children, they know and they're all in agreement this is what Dad wants to have happen. Guardianship designations, you got young kids, I want my brother to take care of them. That's understandable. And then beneficiaries. A lot of people don't think about beneficiaries as being part of an estate plan. But if you've got accounts, and that would be a bank account, IRA, a 401k, a brokerage account, if you have accounts where you can attach a beneficiary that says, I want it to go here or here, do that. That's so important. It bypasses probate and will get your assets to your loved ones, the ones you intend to send them to, a lot more efficiently, a lot more easily. So beneficiaries are important, and I caution you, be sure that you have the correct beneficiary on all of these accounts. Don't be the guy like I worked with at one time that, okay, here we are, I'm with John, John passes away, and we console his wife, and we bury John, and then not that long after we bury John, we try to get the life insurance policy, and come to find out that John's life insurance policy, $500,000 death benefit, did not go to his wife, but it went to his ex-wife because he never changed the beneficiaries on the account. So I would encourage you to get a copy, a hard copy, of who the beneficiary is on all of your accounts. So let's move on to the next one. You know, that was a high level of areas, and you know, we as individuals make mistakes sometimes with these documents. Well, let's go ahead and have a little bit more fun, although it still is a serious thing, and see some common mistakes made by some not so common people. So if anyone remembers Justice Warren Burger, he was the Chief Justice of the Supreme Court, a lawyer. Pretty sharp guy, right? Well, what did he do? He had a handwritten will, only 176 words. He even misspelled his son's name. So what happened? Everything that was in the will went through probate. So there were unnecessary probate expenses, and it cost his heirs approximately $450,000 in avoidable taxes. So my takeaway here is sometimes you get what you pay for. He didn't pay for any estate planning help, but he did in the end, and his heirs paid $450,000. And one of the things you might hear about probate is, oh, my estate is not so large, or probate is only a small percentage of the estate, so it's not all that expensive, and it'll probably take 9 months. Got some good friends that we finally convinced, all right, you need to get this taken care of. And unfortunately, they passed away before they got it taken care of. And the estate turned out to be in probate for 4 years plus, and they had a lawyer helping with it, and you can imagine the lawyer's fees month after month after month. So don't procrastinate on that. Let's get that done. 2, Heath Ledger. Do you remember him as the Joker in The Dark Knight? I've talked about before in other of these sessions, you have life happens situations sometimes, and you have to adjust your plan and your estate plan when that happens. So what happened? He didn't update his estate plan after the birth of his daughter, and he had left originally the estate to his parents and siblings. So, you know, that could be beneficiaries, that could just be through the will or through a trust. He didn't update it. So his daughter was completely left out. Bitter battle among family members, and that's not something you want when you pass away. I want to avoid it, that any of my family should fight over something if I can possibly help it. So not updating your estate plan is not a joking matter. Now I hope y'all are catching the humor here. I'm doing the best I can when I'm looking at a camera, so let's move on. Florence Griffith Joyner. Does anyone remember her, the Olympic sprinter? Look at this. Original estate plan could not be located. So she had an estate plan, but they couldn't find it. The estate remained open for over 4 years. You can imagine what's going on there. Her husband and mother took their disputes to court. Probate courts want original documents. If it's not located, the assumption is they were revoked. So what's the takeaway here? Keep your estate planning documents in a safe place, but not so safe that no one can find them. Okay, so she took some steps to handle her estate, but she didn't leave the documents in a place where someone could find them and actually use them. Michael Jackson, and you do know who I'm talking about, right? The king of pop. He created a revocable living trust as part of his estate plan. That's the right thing to do. especially in his case. So what happened? He never fully funded the estate, and the estate funded the trust, and the estate went through probate. That's why most trusts fail, is that they are not funded properly. So the estate went through probate, incurred unnecessary legal battles and expenses, and became the matter of public record for all to see. So the thing with trusts is they can be completely private. Wills are public, so the public can see what's going on if you file your will. They cannot in a trust. Just another difference in there. So the takeaway here is finish what you started. He started the trust, but he didn't fund it completely. Anybody remember Joe Robbie, the former owner of the Miami Dolphins? So he had to pay estate taxes of $47 million. So that means he was a pretty rich guy. His estate was huge. And what happened? The largest asset he had was the football franchise, and he had to sell it because he needed to pay the taxes. So what's the takeaway? When the state taxes are concerned, or really anything for that matter that can impact what's passed on, plan ahead. It's so important. Here we go, Ted Williams, baseball legend. I have people tell me, don't show this one because it's kind of creepy, but that's all right. It's important because it does tell a good story. So Ted Williams said he wanted to be cremated, but after his death, 2 children produced a note saying he wished to be put in biostasis. So his wishes are not so clear. So his body and his head are separated and frozen while another child is fighting to have them cremated. So, you know, that's kind of a sick situation to be. I remember Ted Williams as a baseball player, and you just don't like to think things like that, but make clear your wishes. You've got to do that. So here's the complete takeaway. Your estate may be small, but what are you going to do in case of incapacitation? Remember the powers of attorney and healthcare power of attorney. Do your accounts point to desired beneficiary? Don't let it go to your ex-wife or to someone else you don't want it to. Check your beneficiaries, make sure they're right. If you have a trust, is it properly funded? Don't be part of the group. I don't know, it may be over 90% of the time when trusts fail, it's because they aren't funded properly. And are your wishes clearly documented? Don't be a Ted Williams if you can possibly help that. So I want to thank you for your attention here, and I hope you found this beneficial, and I hope to be hearing from you soon. Thank you.